In October of 1877, an elderly lodger vanished from a lodging house in Bloomsbury, and no death, no illness, and no cause were ever officially recorded at all. It was 18 months before anyone questioned it. The woman later accused of causing that death was Hannah Dobbs. She was 24 years old, and she was the household's live-in domestic servant, employed in the house where the missing lodger had taken a room. The house stood at number 4, Euston Square, in Bloomsbury, in a district of tall terraced lodging houses built for the transient population that passed through London within reach of the railway termini at Euston, King's Cross and St Pancras. Bloomsbury, in the 1870s, was a respectable but unremarkable quarter, home to clerks, professional lodgers, and persons of modest independent means who rented rooms by the week or the month from landlords who asked few questions about who their tenants had been before they arrived. The house was let by Severin Bastendorf, a maker of bamboo furniture, and his wife Mary Bastendorf, who kept lodgers alongside their own household and children. A live-in servant was employed to manage the domestic work of the house, to lay fires, to fetch coal, to wait upon the lodgers, and to keep the kitchen and cellar in order. That servant, through the period with which this record is concerned, was Hannah Dobbs. Beneath the house ran a coal cellar, used daily for the ordinary business of heating the rooms above, reached by a servant's stair and accessible to household and lodgers alike. It was a house of strangers under one roof, each keeping largely to personal affairs, and it was in exactly this kind of anonymous, transient lodging economy that the case which follows took shape. The documented record of Hannah Dobbs's early life is limited. She is recorded consistently as a domestic servant in service to the Bastendorf family at the time the events described in this record occurred. No confirmed detail survives regarding her parents, her place of birth, or the date she entered service in the household. Her age was recorded as 24 at the time of her trial in 1879, placing her birth at approximately 1855, though no birth record has been confirmed. She is recorded in contemporary and later accounts as having a prior conviction for theft, for which she had served a term of imprisonment before the events at Euston Square came before a court. This prior conviction became part of the record put before the jury at her trial, though it spoke only to a disposition toward dishonesty in the handling of property, and not to any act of violence. Beyond her employment and this earlier conviction, the surviving record does not establish further detail of her circumstances before she came to Euston Square. She lived, worked, and slept within the house, as was customary for a domestic servant of the period, sharing the same rooms, stairs, and cellar as the lodgers she served. If you value cases preserved through court records, testimony, and verified documents, follow or subscribe wherever you are listening. The record resumes in Bloomsbury in 1877. Among the lodgers in the house at that time was a woman calling herself Miss Huish, who had taken a room some time before. Her true name was Matilda Hacker. She had been born in 1811 in Canterbury, Kent, one of the children of John Hacker, a stone engraver and mason of some local standing, whose work is recorded in the fabric of the city itself. He is credited with funding the addition of a clock to the tower of the parish church of St George in Canterbury in 1837. Matilda Hacker never married. She and her unmarried sister, Amelia, became locally known figures in Canterbury and at the nearby seaside resorts of Margate and Ramsgate, where the two sisters were in the habit of promenading the front each summer dressed alike in matching silk gowns, feathered hats, and brooches set with coloured stones, a fashion considered by their neighbours to be more suited to much younger women. Local usage recorded the pair as the Canterbury Belles. Matilda Hacker was a woman of independent means, living on rental income from properties held or inherited from her family, and by 1873 she was recorded as receiving the full income from the Hacker family's Canterbury holdings. She was, by the account of multiple sources, litigious and combative in matters concerning money. She refused at one point to pay local rates on property under her control, and was briefly imprisoned at Westgate in Canterbury as a consequence, with jewellery seized from her to settle the debt. On a separate occasion, she refused to pay for the connection of a mains water supply and left Canterbury rather than settle the account. From the later years of the 1870s, she lived an increasingly transient existence, moving between lodgings under names other than her own, apparently as much from habit as from any settled purpose of evading debt. It was under the name Miss Huish, sometimes rendered Miss Huish, that she had taken her room at number 4 Euston Square. She had no close family resident in London and no relation in the habit of checking on her whereabouts, a circumstance that would prove material to everything that followed. She was, in the words available to this record, a woman known to her own family, chiefly as one who came and went on her own initiative, without explanation and without complaint being thought necessary. The circumstances immediately preceding Matilda Hacker's disappearance from the house are not extensively documented. No dispute, debt, or particular stress specific to her final days at Euston Square survives in the record beyond her general and long-established pattern of financial evasiveness. She held no insurance policy and belonged to no burial club, and nothing in the surviving record suggests she was, in the ordinary sense understood by this record, in other cases, a woman marked out in advance for gain by any policy or arrangement. What the Crown would later allege, when the matter came to court, concerned not a policy or a nursed illness, but the portable property she kept about her jewellery, her clothing, and small items of value that a woman living from lodging to lodging under an assumed name carried as her only fixed possessions. On or about the 14th of October, 1877, while Severin and Mary Bastendorf were away from the house, something occurred within Matilda Hacker's room. The account later given by Hannah Dobbs was that Hacker gave her £5 the following day and departed from the house 2 days after that, in the ordinary way of a lodger giving up a room. Mary Bastendorf, upon returning to the house, is recorded as having found a large bloodstain upon the carpet of the room lately occupied by Miss Huish, a stain that appeared to have been the subject of an attempt to wash it out. No inquiry was made into the stain at the time, and no report was made to any authority. Matilda Hacker was never seen again by anyone who later came forward to say so. Her room was in due course let to a new lodger, and such belongings as remained were dispersed in the ordinary course of running a lodging house, without any member of the household treating her departure as unusual. No death was witnessed, no physician attended a decline, and no death was certified by any doctor, because no doctor was ever called to attend Matilda Hacker in the period concerned. There was no funeral, no death notice placed in any newspaper by family or household, and no illness recorded by any person who later gave testimony. This is not a case in which a woman was nursed through a slow decline while a household watched. The presumed date of death is a matter on which the surviving record is genuinely divided. Hannah Dobbs' own account placed Matilda Hacker's departure from the house in October of 1877. The police, when the matter eventually came to investigation, estimated from the condition in which remains were later found that death had more probably occurred in the autumn of 1878, nearly a full year later than the household's account allowed. This discrepancy between the household's account and the police's later forensic estimate was never resolved, and it remains unresolved in the historical record to this day. What followed the disappearance of Matilda Hacker from number 4 Euston Square was not suspicion, inquiry, or alarm. It was 18 months of ordinary domestic life, continuing without interruption in a house that gave no sign of anything amiss. No member of the household treated Miss Huish's failure to reappear as remarkable, because she had never been the kind of lodger whose comings and goings anyone thought to track. Her own family in Canterbury made no inquiry after her whereabouts in London, because she was already, to them, a woman who vanished under names not her own, and reappeared according to no schedule anyone could predict. The household went on. Lodgers arrived and departed, meals were prepared, fires were laid, and the coal cellar beneath the house continued in its ordinary daily use, opened and closed, filled and emptied by the servant whose duty it was to keep the house supplied with fuel. For 18 months, coal was fetched from that cellar for kitchen and hearth, without any person in the house suspecting that anything other than coal lay within it. The coal fetched each day was carried up a narrow servant stair by whichever member of the household had been assigned the task, most often Hannah Dobbs herself, and the cellar was not a place any lodger had occasion to enter beyond the servant whose duty required it. It was reached through a low doorway beneath the main stair, unlit except by whatever candle or lamp the servant carried down with her, and it held, besides the coal itself, the ordinary accumulation of a lodging house's discarded material, broken furniture, old boxes, and refuse set aside rather than carried out. A cellar of this kind was not swept or cleared in its entirety at regular intervals. Coal was shovelled from the nearest accessible portion of the heap, and the deeper or further reaches of the space were disturbed only when the supply ran low enough to require it. This is the physical detail on which the entire 18 months turned. A body, once placed in such a space and covered by the ordinary matter of a working cellar, coal, ash, discarded boxes, needed no elaborate concealment to remain undiscovered, because the space was by its nature already disordered, already dim, and already visited only briefly and for a single narrow purpose by a servant intent on filling a scuttle and returning upstairs. Mary Bastendorf, in later testimony, gave no account of having gone into the cellar herself during this period, her domestic responsibilities lying with the running of the household above rather than with the fetching of fuel. Severin Bastendorf's own business, the manufacture of bamboo furniture, was conducted from workshops separate from the house, and nothing in the surviving record places him in the cellar at any point during the 18 months in question. The lodgers who came and went in that time had no occasion to descend below stairs at all. Coal was brought up to their rooms, not fetched by them. The only person with regular, sanctioned, unremarked access to the cellar throughout the whole of the period was the household servant. This is stated in the record plainly, without further comment on what it may or may not imply, because the record itself draws no conclusion from it beyond the bare fact of access. The ordinariness of this period is the feature of the case that most distinguishes it from other domestic killings of the era. In many of the cases this record has occasion to describe, a death is followed within days or weeks by a widening circle of suspicion, a remark repeated among neighbours, a doctor who declines to sign a certificate, an inquest convened within the month. Here, nothing of the kind occurred. The household's daily routine did not pause. Rent was collected from lodgers on the usual days. Meals were prepared at the usual hours. The Bastendorf children were raised in the house, as before, playing on staircases that led, ultimately, down to the space beneath them. Tradesmen called at the door. New lodgers arrived to take rooms vacated by those who departed. Among them, eventually, the room that had been let to Miss Huish, taken up by a lodger with no knowledge of who had occupied it before. None of this activity was performed by people who suspected anything, because nothing had occurred, so far as any of them knew, to suspect. A woman who had never given her true name, who had no fixed correspondence with anyone in the house, and whose family did not expect to hear from her at predictable intervals, had simply stopped being present. In a lodging house, a lodger's departure required no further comment than the letting of the room to someone new. Hannah Dobbs, in the period following Matilda Hacker's disappearance, continued in service at the house for a time before eventually leaving that employment. Though the precise date and circumstances of her departure from the Bastendorf household are not established with confidence in the surviving record. What is established is that certain items later identified as having belonged to Matilda Hacker passed during this period into Dobbs's possession and were in due course pawned by her at premises in London. Among these items was a gold watch, together with other pieces of jewellery consistent with the flamboyant style of dress for which Hacker and her sister had been known in Canterbury. An empty cash box, also identified as having belonged to Hacker, was found to have passed into the household as well. One source records that this box was given, at some point, to one of the Bastendorf children, apparently without any person in the house at that time attaching significance to its presence or its origin. None of this activity, the pawning of a watch, the appearance of a cash box among a child's possessions, attracted attention or comment at the time it occurred. It was only much later, once investigation had begun, that these transactions were traced and assembled into a sequence. The 18 months during which Matilda Hacker's remains lay beneath the house, undiscovered, were not 18 months of active concealment on the part of any person, so far as the surviving record establishes. There is no account of anyone returning to the cellar to disturb, rearrange, or further conceal what had been placed there. There is no account of any person expressing private unease, of a servant declining to go below stairs, or of a change in household behaviour that a later witness could point to as, in hindsight, a sign. The absence of such detail is itself part of the record, and it should not be supplied where the sources do not supply it. What can be stated is that the coal continued to be fetched, the fires continued to be laid, and the ordinary business of a Bloomsbury lodging house continued directly above a concealment that no one in the house had any reason to imagine. Suspicion, when it came, arrived not as the slow accumulation of doubt, but as a single physical event. On the 9th of May 1879, workmen were engaged in clearing the coal cellar at number 4, Euston Square, a routine domestic task unconnected to any inquiry, undertaken because the cellar required clearing in the ordinary course of managing the house's fuel supply. Among those engaged in this work was a 15-year-old errand boy named William Stroman. In the course of clearing the coal, Stroman uncovered human remains. There was no gradual dawning of concern in the days before this moment, no accumulating rumour in the neighbourhood, no letter from a worried relative that finally prompted someone to look. The discovery converted within the space of a single afternoon an unremarked 18-month absence into the discovery of a body and the opening of a criminal investigation. William Stroman's find was reported at once to the police, and from that point the matter passed out of the hands of the household entirely and into those of the Criminal Investigation Department. The remains, when examined, were found to be badly decomposed, consistent with a period of concealment estimated by police at approximately 18 months, a period broadly consistent with, though not identical to, the interval since Matilda Hacker's disappearance from the house. A rope was found knotted about the neck of the remains, a detail treated by investigators as an indication of violence, though the state of decomposition was such that the precise manner and cause of death could not be established with clinical certainty from the remains alone. The condition of the remains made visual identification by any person impossible, and the process of establishing who had died therefore proceeded not through recognition, but through the reconstruction of identity from surrounding evidence, a process that would occupy investigators over the following weeks. The first thread in that reconstruction was clothing. Remnants of a distinctive black silk dress were recovered with the remains, along with a brooch, both consistent with descriptions of the flamboyant style of dress for which Matilda Hacker and her sister had been known since their days promenading the seafront at Margate and Ramsgate. This alone was suggestive rather than conclusive, since a style of dress, however distinctive, could not by itself identify a particular woman with certainty. The investigating officer recorded across multiple sources, as Inspector Charles Hagan of the Criminal Investigation Department pursued a second and more exacting line of inquiry, tracing a dentist who recalled having made a set of dentures for a woman matching the general description of the deceased, a woman who had never returned to collect the completed work or to settle the account owed for it. This unclaimed dental work, matched against the remains, provided a form of physical correspondence considerably more specific than clothing alone. The third and final element in the identification was personal rather than forensic. Edward Hacker, Matilda Hacker's brother, was brought to view the effects recovered with the remains, the dress, the brooch, and the dental evidence together, and he identified them as belonging to his sister. It should be stated plainly that this identification was achieved through recognition of her effects and her dentition, and through her brother's testimony regarding those effects, rather than through any recognition of her face or features, which the condition of the remains did not permit. Taken together, the clothing, the unclaimed dentures, and her brother's identification of these effects were treated by investigators as sufficient to establish, to the standard required for the case to proceed, that the remains were those of Matilda Hacker. The investigation that followed the identification of the remains turned quickly to the household in which Matilda Hacker had lodged, and in particular to the servant who had been present throughout the whole of her residency and who had since left that service. Investigators traced the watch and jewellery that Hannah Dobbs had pawned in the period following Hacker's disappearance, locating the pawnbroker who had accepted the items and who was able to identify Dobbs as the person who had brought them in. The empty cash box, recovered from where it had passed into the Bastendorf household, was likewise traced back to Hacker's ownership. When questioned regarding how she had come into possession of these items, Dobbs gave accounts that investigators found inconsistent from one telling to the next, though the surviving record does not preserve the precise wording of these statements. On the strength of this circumstantial chain, her possession of the dead woman's property, her presence throughout the period of the disappearance, her prior conviction for theft, and the inconsistency of her explanations, Hannah Dobbs was committed for trial on a charge of wilful murder. An inquest into the death of Matilda Hacker was convened following the discovery of her remains, in the ordinary course required by law whenever a body was found under circumstances suggesting violence. The specific coroner who presided, the date on which the inquest sat, and the individual witnesses called before it are not established with confidence in the surviving record. What can be stated with confidence is that the inquest proceeded from the discovery of the remains to a finding sufficient to support a charge of wilful murder, and that it was as a consequence of the investigation conducted in this period that Hannah Dobbs was committed to stand trial at the Central Criminal Court. The 18 months of undisturbed domestic routine above the cellar had come to an end, replaced now by depositions, witness statements, and the machinery of a capital charge, all of it converging toward a courtroom at the Old Bailey. The trial of Hannah Dobbs opened at the Central Criminal Court on the 30th of June, 1879, with her own arraignment and the substance of the case against her beginning on the 2nd of July, before Mr. Justice Hawkins, one of the leading criminal judges then sitting at the Old Bailey. Dobbs was arraigned on a charge of wilful murder, to which she entered a plea of not guilty. Under the law, as it then stood, an accused person could not give sworn evidence in her own defence, and Dobbs did not testify. The case against her was presented by counsel for the Crown, and the case for her defence by counsel retained on her behalf, though the names of the barristers who appeared on either side are not confirmed in the surviving record, and none are named. The prosecution's case rested entirely on circumstance, lay before the jury piece by piece. It was established that Dobbs had been the household's live-in servant throughout the whole of Matilda Hacker's residency at No. 4, Euston Square, present in the house every day of the period during which Hacker vanished. It was established through the pawnbroker's testimony that a gold watch and other items of jewellery later identified as belonging to Hacker had been brought in and pawned by Dobbs herself, in her own person at a shop in London. It was established that an empty cash box, likewise identified as Hacker's property, had passed into the Bastendorf household during the period after her disappearance. The Crown set before the jury the explanations Dobbs had offered for her possession of these items, characterising them as shifting and inadequate to account for property that had, by every other thread of evidence, belonged to a woman last seen alive in the house where Dobbs served. The Crown further placed before the jury Dobbs's prior conviction for theft, offered not as evidence that she had committed murder, but as evidence bearing on her character and her willingness to take property that was not her own. Taken together, this was the whole of the Crown's case: opportunity, established through her presence in the house; possession, established through the pawned items and the cash box; and a pattern of dishonest explanation, established through her own shifting account of how these things had come into her hands. No witness was called who had seen an act of violence. No witness placed a weapon, a rope, or any instrument in Dobbs's hand. The case was, from its first witness to its last, a case built entirely on what she was found to have and what she said about having it. Counsel for the defence met this case on its own ground, arguing that proof of theft, however clearly established, was not proof of murder, and that the two charges, however connected in the Crown's presentation, required entirely separate evidence to sustain. The defence pressed the physical difficulty of the Crown's implicit theory that a young woman, slight in build and alone, could kill an adult woman within a lodging house occupied by a family and other lodgers, carry or drag the body down a servant's stair to the cellar, conceal it there, and clean a heavily blood-stained carpet thoroughly enough to escape remark for 18 months, all without a single other resident of the house seeing, hearing, or later recalling anything amiss. The defence noted that Mary Bastendorf herself had found the bloodstain upon returning to the house, and had made nothing of it at the time, a fact the defence used to suggest that the household's own contemporaneous response to what should, in hindsight, have been an alarming discovery, undercut any theory that concealment on this scale had been accomplished by one person acting without any assistance or awareness from those around her. No medical witness was able to fix a precise time or cause of death that could be tied specifically to any act by Dobbs, and the defence made much of this gap between the physical evidence recovered from the cellar and the specific charge the jury was being asked to return. In his summing up to the jury, Mr. Justice Hawkins directed that the evidence before them, however strongly it might point to dishonesty in Dobbs's handling of the dead woman's property, could not by itself be treated as sufficient to sustain a conviction for murder. Multiple accounts of the trial describe this summing up as favouring acquittal, some characterising it as surprisingly so given the weight of the circumstantial property evidence the Crown had assembled over the preceding days. The jury retired to consider its verdict and returned finding Hannah Dobbs not guilty of the charge of wilful murder. She was discharged from the dock a free woman. No other person was ever charged with the killing of Matilda Hacker, and the question of who had placed her body in the cellar and by what means she had died was left at the conclusion of the trial exactly where it had stood before the trial began. There was no sentence to be carried out and no term of imprisonment to be served because Hannah Dobbs had been acquitted, and the record that follows her discharge from the dock takes a turn that few cases of this kind produce. Shortly after her acquittal, a publisher of penny periodicals named George Purkis arranged to issue Dobbs's own account of her years in the Bastendorf household, printed and sold as a pamphlet under a title announcing itself as the extraordinary statement made by Hannah Dobbs concerning the Euston Square mystery. In this pamphlet, sold on the streets to a public already familiar with her name from months of press coverage, Dobbs stated that she had, during her time in service at the house, carried on an affair with her employer, Severin Bastendorf, the bamboo furniture maker who held the lease on number 4, Euston Square. the pamphlet went further, implicating Bastendorf, by suggestion, rather than direct accusation, in the death of Matilda Hacker. Further allegations, attributed to Dobbs in this period, are less well corroborated across the surviving sources. Severin Bastendorf had in earlier proceedings connected to the case denied under oath that any improper relationship existed between himself and his former servant. Confronted now with a printed pamphlet circulating publicly and asserting the opposite, Bastendorf brought, or was drawn into, a libel action against George Purkis over the pamphlet's claims. The hearing that followed produced evidence that Dobbs and Bastendorf had, at one point, stayed together at an inn in Surrey, with Dobbs posing during that stay as his wife. This evidence was sufficient to establish, to the satisfaction of the court hearing the libel action, that the affair described in the pamphlet had in fact taken place. The consequence followed directly from that finding. George Purkis was acquitted of libel, since the substance of what he had published was shown to be true. Severin Bastendorf, having sworn under oath in earlier proceedings that no such relationship existed, was convicted of perjury for that sworn denial and was sentenced to 12 months' imprisonment, with hard labour, according to some accounts of the sentence. The household's own master, the man who had employed both the missing lodger and the servant later tried for her murder, was the only person connected to the case at Euston Square who was ultimately convicted of anything at all, and what he was convicted of was lying under oath about his own conduct, not about the death that had brought the case into being. What became of Severin Bastendorf after his release from prison is not established with confidence in the surviving record. What the record does establish with confidence is the sequence itself. A servant tried and acquitted of murder, and the man who had employed her convicted, in a separate and later proceeding, of perjury committed in his sworn denial of an affair with that same servant. No document places him, or any other named person, at the scene of Matilda Hacker's death, and no further charge was ever brought against him or against anyone else in connection with it. The case, once it had run its course through the criminal court, and then through the libel action that followed, left a mark on the physical geography of the district in which it had occurred. The public attention attached to number 4, Euston Square, was such that residents and freeholders in the surrounding streets petitioned to have the address itself erased from common usage. A petition led by George Cubitt, a Member of Parliament and local freeholder, together with other leaseholders in the square, was brought before the Metropolitan Board of Works, and on the 5th of December, 1879, the southern side of Euston Square was formally renamed Ensley Gardens. A published source from the years following the renaming described its purpose, in terms preserved by later citation, as an effort to bury the murderous memories attached to the old name beneath the new one. The street on which the house stood no longer carried the name under which the case had been reported. In newspapers as far afield as the Australian colonies, where the trial was covered in the Brisbane Telegraph in August of 1879, evidence of how widely the case had travelled beyond London in the months following the discovery in the cellar. What became of Hannah Dobbs after her acquittal and after the pamphlet that bore her name is not established in any surviving source. No marriage record, no death record, and no further mention of her under her own name has been traced beyond the period immediately surrounding the trial and the libel action that followed it. She does not reappear in the census returns under a name confidently linked to her prior identity, and no obituary, no later court appearance, and no correspondence bearing her name has come to light in the modern research conducted into the case. A woman who had spent the whole of the period covered by this record in service to others, without property, without family connections in London, and without a fixed address of her own, beyond whatever room came with whatever position she held, left London's official record as quietly as Matilda Hacker herself had once slipped out of the notice of her own family. The investigation that had identified Matilda Hacker's remains and traced the pawned jewellery back to Hannah Dobbs had been conducted by the Criminal Investigation Department, a branch of the Metropolitan Police that was itself, at the time of the case, barely a year old. The department had been established in 1878 in the aftermath of a scandal in which senior detectives of the older detective branch had been convicted of corruption, a scandal that had badly damaged public confidence in plainclothes policing generally. The Euston Square case therefore fell to a body of investigators still establishing its methods and its credibility, working a case in which the central evidence was not a confession, not an eyewitness, and not a weapon, but a chain of pawned property traced backward from shop to servant to victim. The case illustrated, in the plainest possible terms, a limitation in the criminal law of the period that the defence at trial had exploited directly. Proof that a person held stolen property, however damning it appeared, was not proof that the same person had taken a life to obtain it. A charge of murder required evidence of the killing itself, and no such evidence, direct or circumstantial, was ever produced in court that could be tied specifically to any act by Hannah Dobbs or by any other named individual. The world in which Matilda Hacker disappeared without remark for 18 months was a world defined by exactly this kind of anonymity. London's lodging houses in this period housed a large and constantly shifting population of individuals living apart from family, often under names not their own, paying rent by the week to landlords whose only real interest was that the rent be paid on time. There existed no institutional mechanism by which a missing lodger, one who simply stopped appearing at meals and stopped paying for a room, would be reported, tracked, or investigated unless some particular person outside the house took it upon themselves to raise the alarm. Matilda Hacker, by her own long history of evading rates, debts, and now her own name, had made herself, without any intention of doing so, into precisely the kind of person for whom this system offered no protection at all. She had spent years perfecting the art of disappearing from creditors and local authorities who wished to collect from her. When she disappeared for the last time, the same skill that had kept her ahead of the rate collector and the water company ensured that no one thought to look for her either. Historical and popular treatments of the case, produced in the decades since, have continued to weigh the evidence on both sides, but without arriving at a settled conclusion. The case for Hannah Dobbs's guilt rests on her proven possession of the dead woman's property, on her unmatched opportunity as the one person in the household with regular, unremarked access to both Hacker's room and the cellar beneath the house, on her documented prior conviction for theft, and on the inconsistency of the explanations she gave for how Hacker's watch and jewellery came into her hands. The case against her guilt rests on the complete absence of any evidence placing her hand on the rope found about the remains, on the physical improbability, never resolved at trial, of a young woman alone overpowering, killing, and concealing an adult body without detection by an entire household living above her, and on the judge's own summing up, which leaned toward the view that proprietary evidence, however suspicious, could not sustain a capital charge. It rests also on the fact that the household itself, the Bastendorfs, had access to the same rooms and the same cellar, and that Severin Bastendorf's own, later, separately proven willingness to lie under oath in a matter unconnected to the killing itself, has invited later writers to ask what else his sworn word might not be trusted to establish. Modern popular history has treated the case as one of the enduring unsolved mysteries of Victorian London, revisited in a 2018 book examining the murder at number 4, Euston Square, and in more recent independent studies of the evidence, none of which claims to have settled the question the jury itself left open in 1879. The volume of contemporary press coverage the case generated is itself a matter of record. Beyond the provincial and national newspapers of England, beyond the coverage carried as far as Queensland, the case was picked up and followed by penny weeklies of the kind Perkes himself published, publications that specialised in exactly this sort of material: trial reports, illustrated depictions of the courtroom, and serialised accounts of ongoing investigations, sold cheaply to a reading public with an appetite for real crime, rendered in the same narrative form as fiction. The Illustrated Police News, the publication most closely associated with Perkes's stable of titles, had built its circulation over the preceding decade precisely on cases of this kind, cases combining a body, a mystery, and a courtroom drama, illustrated with woodcuts depicting scenes the artist had not witnessed and could only imagine from the trial reports. Dobbs's own pamphlet, issued in the immediate aftermath of her acquittal, belonged to this same publishing world, a world in which an acquitted woman's own voice, printed and sold for a penny, could itself become the next chapter of a story the public had already been following for months. Later, historical treatments of the case have continued to draw on this same body of contemporary material. A study published by the Canterbury Archaeological Trust examined Matilda Hacker's Canterbury background in detail, tracing her family's standing in the city and the properties her father's stonework had left behind in its churches. Independent researchers in more recent years have compiled the surviving evidence into fuller narrative accounts, weighing the same circumstantial case the jury weighed in 1879 against the century and a half of hindsight since. True crime writers and researchers maintaining online record of historical cases have returned to the file repeatedly, drawn by the same features that distinguish it within this record. A body concealed for 18 months beneath an occupied and functioning household, an identification achieved without a face to recognise, an acquittal that left the killing formally unsolved, and an aftermath in which the household's master, rather than its servant, was the only person ultimately convicted of anything. The relationship between Hannah Dobbs and the household she served reflects a wider pattern in domestic arrangements of the period, in which a servant lived under the same roof as her employers and their lodgers, sharing their meals in a separate sitting, sharing their stairs, and yet remaining in matters of standing, credit, and belief entirely subordinate to them. When suspicion eventually settled on a member of the household, it settled first and almost exclusively on the servant, the person with the least standing to defend herself against it, rather than on the master of the house, whose own later proven willingness to lie under oath came to light only because a separate and unrelated allegation forced the question into a courtroom. Amelia Hacker in Canterbury outlived her sister by an unrecorded number of years, and no account survives of her response to the discovery of Matilda's remains or to the trial that followed, beyond the bare fact that it was Edward Hacker, their brother, rather than Amelia, who travelled to view the effects recovered from the cellar and to give the identification the case required. Before the case reached the Central Criminal Court, Hannah Dobbs was brought before a magistrate at the police court with jurisdiction over the district. In the preliminary proceeding required under English law, before any person could be sent forward to stand trial on an indictable charge. This committal hearing, conducted in the weeks following her arrest, was not a trial in the full sense the Old Bailey proceeding would later be, but a hearing at which the prosecution was required to lay before the magistrate sufficient evidence to justify holding the accused for trial by jury. The pawnbroker who had accepted the watch and jewellery gave his account at this stage, describing the transaction in which a young woman, later identified to him as Dobbs, had brought in the items and received payment against them, entered in the shop's own ledger under the ordinary business of the trade. Pawnbroking of this kind was a routine feature of working life in London in this period, a means by which persons short of ready money could raise cash against the security of a valuable object, redeemable later upon repayment with interest, or forfeited to the shop if the loan went unclaimed. The transaction Dobbs conducted was, on its face, indistinguishable from the thousands of others carried out across the city every week. A young woman bringing in a watch and receiving a sum of money in exchange for a ticket entitling her to reclaim it. It was only the later identification of that watch as Matilda Hacker's property that transformed an unremarkable pawnshop transaction into evidence in a capital case. The magistrate, having heard the evidence assembled by the police, the pawnbroker's testimony, the tracing of the cash box into the household, and the account of Dobbs's presence throughout Hacker's residency, found sufficient grounds to commit her for trial on the charge of wilful murder, remanding her into custody to await the sitting of the Central Criminal Court. This committal proceeding, brief and procedural as it was, marked the formal point at which the matter passed from police investigation into the machinery of the criminal courts, and it was on the strength of the case assembled and tested at this stage that the indictment eventually placed before the jury at the Old Bailey was drawn. The interval between committal and trial was occupied, on the prosecution side, with the further tracing of pawned items and the securing of witnesses, including Edward Hacker's journey from Canterbury to view his sister's effects, and on the defence side, with the preparation of the arguments concerning physical improbability and the insufficiency of proprietary evidence that counsel would later press before Mr. Justice Hawkins and the jury. The courtroom in which Hannah Dobbs stood trial occupied the principal sessions house of the Central Criminal Court, adjoining Newgate Prison, a building whose public gallery had, by 1879, become a fixture of London's appetite for cases exactly like this one. Given the volume of press coverage the case had already generated in the weeks between the discovery of the remains and the opening of the trial, the gallery would have been crowded for the duration of the proceedings, filled with members of the public, drawn by a case that newspapers, as far away as Australia, had already been following for weeks. Reporters occupied benches set aside for the press, transcribing testimony that would appear in the following morning's editions across London, and in condensed form in the provincial papers within days. The jury sworn to try the case sat apart from this public interest, instructed, as juries of the period customarily were, to weigh only the evidence placed formally before them, and to set aside whatever they might already have read or heard of the case in the weeks preceding the trial, an instruction of particular weight in a case that had received as much prior newspaper attention as this one had. Matilda Hacker's financial position, established through property records and through testimony regarding her income, extended beyond the properties she was known to hold in Canterbury itself. Her father's estate had included holdings in the Blackfriars district of the city as well, properties from which rental income continued to accrue to the Hacker family after his death, income that was, by 1873, recorded as passing in its entirety to Matilda as the surviving family member with the strongest claim to it. This income was sufficient to support her without employment of any kind for the whole of her adult life, allowing her the transient existence she pursued in her later years, moving between lodgings under assumed names while rents from properties she never needed to visit continued to reach her by whatever arrangement she had made for their collection. It was this same income, portable in the form of cash, jewellery, and a watch she carried on her person rather than left administered at a distance, that made her a target for exactly the kind of theft the Crown alleged against Dobbs, a woman living on unearned income from property she owned outright, but administered personally, carrying her wealth with her from lodging to lodging in a form that required no bank, no solicitor, and no witness to her possession of it beyond whoever happened to share her roof. The material conditions of Hannah Dobbs's position in the household drew a sharp practical line between the world she inhabited and the world of the lodger she was accused of killing. A single domestic servant of the period, employed in a lodging house of moderate size, could expect wages in the range of £10 to £16 a year, paid quarterly, together with board and a small room, often in the attic or basement of the house, set apart from the rooms let to paying lodgers. Her hours ran from before the household woke until after it slept, laying fires, carrying water and coal, answering the door, cleaning grates and preparing and clearing meals, work that left her with little time and less money of her own. Against this, Matilda Hacker's unearned rental income, arriving whether she rose before dawn or not at all, represented a difference in circumstance that no amount of proximity within the same house could narrow. The two women shared a roof, a staircase, and for a period of some years, the ordinary daily transactions of a servant attending to a lodger's needs. And yet one of them owned property she had never troubled to see, and the other owned, in the fullest legal sense, nothing beyond the clothes in her small room, and whatever wages she had not yet spent. This disparity shaped the case as it unfolded, in ways the trial itself only partly addressed. When suspicion came to rest on a member of the household, it rested on the person whose word carried the least independent weight, a servant with a prior conviction already recorded against her name, rather than on the lodging house's own master and mistress, whose standing in the community and whose position as employers gave their own accounts, at least at the outset, a credibility Dobbs's did not enjoy. It was only later, through the entirely separate mechanism of a libel action brought over a pamphlet, that Severin Bastendorf's own sworn word was tested and found wanting. A reversal that the criminal trial itself, concerned only with the narrower question of Dobbs's guilt or innocence, had no occasion to produce. The record does not establish that this disparity in standing affected the outcome of either proceeding, and no source claims that it did. It states only that the disparity existed, plainly, as a feature of the household in which both women had lived, one as a servant paid by the quarter, the other as a lodger living on income she never had to work to receive. The discrepancy between the date Hannah Dobbs gave for Matilda Hacker's departure from the house and the estimate later reached by police examiners was never resolved during the investigation or at trial, and it remains, in the historical record, one of the case's genuine unanswered questions. Dobbs's account, given after the discovery of the remains, placed Hacker's departure in October of 1877, a date that would place the concealment at closer to 19 months by the time the remains were found in May of 1879. The estimate reached by those who examined the remains, based on the extent of decomposition observed in the cellar, suggested a somewhat later date, placing death more probably in the autumn of 1878, nearer to 18 months before discovery rather than 19. The difference between these two accounts, roughly a year, was substantial enough to matter to the case, since it bore directly on whether Dobbs's own account of Hacker's final days in the house could be trusted at all, or whether it represented instead an attempt to place the disappearance a full year earlier than it had actually occurred. Estimating an interval since death from the condition of skeletal and partially preserved remains was in 1879 a matter of the examining officer's accumulated experience rather than any standardized scientific test, and the surviving record does not preserve the specific reasoning by which the estimate of 18 months was reached, beyond the general fact that the state of decomposition was consulted for this purpose. No forensic pathologist in the modern sense examined the remains, and no laboratory analysis fixed the date with precision. The conclusion offered at the time was an estimate arrived at by observation, and it was treated at trial as suggestive rather than conclusive, consistent with the broader pattern in which no single piece of medical evidence, in this case, was permitted to carry more weight than its actual certainty allowed. Neither the prosecution nor the defence resolved the discrepancy in the course of the trial, and the jury was left to weigh Dobbs's account against the examiner's estimate without either being definitively confirmed or ruled out. A gap in the record that persists in every subsequent retelling of the case down to the present. The jury returned a verdict of not guilty. She was acquitted No other person was ever charged. The death of Matilda Hacker has never been attributed to anyone else.